Republic Act Number 10175, an act defining cybercrime, providing for the prevention, investigation, suppression, and the imposition of penalties, therefore, and for other purposes. Chapter 1, Preliminary Provisions. Section 1, title, This Act shall be known as the Cybercrime Prevention Act of 2012, which thoroughly addressed crimes done against and by means of computer system on 12 September 2012. It consists of substantive, penal provisions, procedural rules, and international. Section 2, Declaration of Policy. The state recognizes the vital role of information and communications industries such as content production, telecommunications, broadcasting, electronic commerce, and data processing in the nation's overall social and economic development. The state also recognizes the importance of providing an environment conducive to the development, acceleration, and rational application and exploitation of information and communications technology (ICT) to attain free, easy, and intelligible access to exchange and/or delivery of information, and the need to protect and safeguard the integrity of computer communication systems, network, and databases, and the confidentiality, integrity, and availability of information and data stored therein from all forms of misuse, abuse, and illegal access by making punishable under the law such conduct or conducts. In this light, the state shall adopt sufficient powers to effectively prevent and combat such offenses by facilitating their detection, investigation, and prosecution at both the domestic and international levels, and by providing arrangements for fast and reliable international cooperation. Its purpose is to uphold and further every individual's right to appropriate, relevant, high-quality education at all levels. C. Communication refers to the transmission of information through ICT media, including voice, video, and other forms of data. Computer refers to an electronic, magnetic, optical, electrochemical, or other data processing or communications device or grouping of such devices capable of performing logical, arithmetic, routing, or storage functions, and which includes any storage facility or equipment of communication facility or equipment directly related to or operating in conjunction with such device. It covers any type of computer device, including devices with data processing capabilities like mobile phones, smartphones, computer networks, and other devices connected to the internet. C. Communication refers to the transmission of information through ICT media, including voice, video, and other forms of data. Computer refers to an electronic, magnetic, optical, electrochemical, or other data processing or communications device or grouping of such devices capable of performing logical, arithmetic, routing, or storage functions, and which includes any storage facility or equipment of communication facility or equipment directly related to or operating in conjunction with such device. It covers any type of computer device, including devices with data processing capabilities like mobile phones, smartphones, computer networks, and other devices connected to the internet. Computer data refers to any representation of facts, information, or concepts in a form suitable for processing in a computer system, including a program suitable to cause a computer system to perform a function, and includes electronic documents and or electronic data messages, whether stored in logical computer systems or online. Computer program refers to a set of instructions executed by the computer to achieve intended results. Computer system refers to any device or group of interconnected or related devices, one or more of which pursuant to a program performs automated processing of data. It covers any type of device with data processing capabilities, including
but not limited to, computers and mobile phones. The device consisting of hardware and software may include input, output, and storage components which may stand alone or be connected in the network or other similar devices. It is also includes computer data storage devices or media. Without right refers to either conduct undertaken without or in excess of authority, or conduct not covered by established legal defenses, excuses, court orders, justifications, or relevant principles under the law. Cyber refers to a computer or a computer network, the electronic medium in which online communication takes place. Critical infrastructure refers to the computer systems and or networks, whether physical or virtual, and or computer programs, computer data, and or traffic data so vital to this country that the incapacity or destruction of or interference with such system and assets would have a debilitating impact on security, national or economic security, national public health and safety, or any combination of those matters. Cybersecurity refers to the collection of tools, policies, risk management approaches, actions, training, best practices, assurance, and technologies that can be used to protect the cyber environment and organization and users' assets. Database refers to a representation of information, knowledge, facts, concepts, or instructions which are being prepared, processed or stored or have been prepared, processed or stored in a formalized manner and which are intended for use in a computer system. Cybersecurity refers to the collection of tools, policies, risk management approaches, actions, training, best practices, assurance, and technologies that can be used to protect the cyber environment and organization and users' assets. Database refers to a representation of information, knowledge, facts, concepts, or instructions which are being prepared, processed or stored or have been prepared, processed or stored in a formalized manner and which are intended for use in a computer system. Interception refers to listening to, recording, monitoring, or surveillance of the content of communications, including procuring of the content of data, either directly through access and use of computer system or indirectly through the use of electronic eavesdropping or tapping devices at the same time that the communication is occurring. Service provider refers to any public or private entity that provides the users of its service the ability to communicate by means of a computer system, and any other entity that processes or stores computer data on behalf of such communication service or users of such service. Subscribers information refers to any information contained in the form of computer data or any other form that is held by a service provider relating to subscribers of its services other than traffic or content data, and by which identity can be established, the type of communication service used, the technical provisions taken thereto, and the period of service. The subscriber's identity, postal or geographic address, telephone and other access numbers, any assigned network address, billing and payment information available on the basis of the service agreement or arrangement, and any other available information on the site of the installation of communication equipment available on the basis of the service agreement or arrangement. Traffic data or non-content data refers to any computer data other than the content of the communication, including but not limited to the communication's origin, destination, route, time, date, size, duration, or type of underlying service.
This is about the deliberate or careless introduction or spread of viruses, as well as the change, destruction, deletion, or degradation of computer data, electronic documents, or electronic data messages without authorization.
Section 5. Other offenses. The following act shall also constitute an offenses. A. Aiding or abetting. In the commission of cybercrime, any person who willfully abates or aids in the commission of any of the offenses enumerated in this act shall be held liable. B. Attempt in the commission of cybercrime. Any person who willfully attempts to commit any of the offenses enumerated in this act shall be held liable. Based on my understanding, for Section 5 is all people who is involved to or circumstances or attempts to threaten or go against a person discriminating, humiliating, or creating chaos on media platforms or the internet web shall be held liable by the law. Section 6. All crimes defined and penalized by the Revised Penal Code, as amended, and special laws if committed by through and with the use of information and communications technologies shall be covered by the relevant provisions of this act, provided that the penalty to impose shall be 1 degree higher than that provided for the Revised Penal Code as amended and special laws as the case may be. Based on my understanding of Section 6, all crimes with the use of electronic material shall be held responsible for the ownership and misuse of any wrongful information, and such as injustice act will be given a degree higher than the previous penalty as per the new Revised Penal Code. Section 7. Liability under other laws. A prosecution under this act shall be without prejudice to any liability for violation of any provision on the Revised Penal Code as amended or special law. Based on Section 7, when the accused is under the trial of the prosecutor, no harm or maltreatment shall be allowed liable to the accused going under the legal process and just mean. Chapter 3. Penalties. Section 8. Penalties. Any person found guilty of any of the punishable act enumerated in Section 4A and 4B of this act shall be punished with the imprisonment or prison, mayor, or a fine of at least 200,000 pesos up to a maximum amount commensurate to the damage incurred or both. Another slide of Section 8 Penalties. Any person found guilty of the punishable act under Section 4A5 shall be punished with the imprisonment of prison, mayor, or a fine of not more than 500,000 pesos or both if punishable act in Section 4A are committed against critical infrastructure, the penalty of reclusion temporal, or a fine at least 500,000 pesos up to the maximum amount commensurate to the damage incurred or both shall be imposed. Another page of Section 8 Penalties. Any person found guilty of any of the punishable act enumerated in Section 4C1 of this act shall be punished with the imprisonment of prison, mayor, or a fine at least 200,000 pesos but not exceeding 1 million pesos or both. Any person found guilty of any punishable act enumerated in Section 4C2 of this act shall be punished with the penalties as enumerated in Republic Act No. 9775 or the Anti-Child Pornography Act of 2009, provided that the penalty to be imposed shall be 1. Based on my understanding about Section 8 penalties, is any person founded guilt after the trial shall have to prison mayor. The penalty of prison mayor shall carry with the temporary, absolute disqualification and that of perpetual special disqualification from the right of suffrage which the offender shall suffer of the pardoned as to the principal penalty unless the same shall have been expressly remitted in the pardon. This without a say could go from 6 years and a day imprisonment unto 12 years, with or without the penalties or fines, but could be given both at the same time under the Cybercrime Law Revised Penal Code.
Section 9. Corporate Liability. A corporation is liable, therefore, whenever a tortuous act is committed by an officer or agent under express direction or authority from the stakeholders or members acting as a body, or generally from the directors as the governing body. Corporate liability under RA 175 is published by a fine ranging from 5 billion to 10 million without prejudice to the criminal liability of corporate officers. The Cybercrime Prevention Act of 2012, also known as the Republic Act No. 101-175. Section 10. Law Enforcement Authorities. The Philippine Congress enacted Republic Act No. 175 or Cybercrime Prevention Act of 2012, which completely addressed crimes committed against and by means of computer system on 12 September of 2012, including penal substantive rules, procedural rules, and also rules on international cooperation. The National Bureau of Investigation or NBI and the Philippines National Police or PNP shall be responsible for the efficient and effective law enforcement of the provision of this act. Section 11. Duties of Law Enforcement. Law enforcement agencies responded to detect and prevent crime. Within this perspective, it is recognized that the police officers play a significant role in adapting and responding to unexpected or unknown situations, as well recognized situations such as theft or domestic dispute. Criminal justice agencies such as law enforcement officers, prosecutors, and judges are responsible for the prevention, mitigation, detection, investigation, and prosecution and adjudication of cybercrime. Section 12. Real-time collection of traffic data. Law enforcement authorities with due cause shall be authorized to collect or record by technical or electronic means traffic data in real time associated with specified communication transmitted by means of a computer system. Specified communication transmitted by means of computer system, traffic data refer only to the communication's origin, destination, route, time, date, size, duration, or type of underlying service, but not content nor identities. All others data to collected or seized or disclosed with required a court warrant.
Section 13. Preservation of computer data. The integrity of traffic data and subscriber information relating to communication services provided by a service provider shall be preserved for a minimum period of 6 months from the date of the transaction. Content data shall be similarly preserved for 6 months from the date of the transaction. Content data shall be similarly preserved for 6 months from the date to receipt of the order from law enforcement authorities requiring its preservation. Law enforcement authorities may order a one-time extension for another 6 months. This statement is outlining the requirement for service providers to preserve traffic data and subscriber information related to communication services for a minimum of 6 months. It also states the content data must be preserved for the same period following an order from law enforcement authorities. Additionally, law enforcement authorities have the option to order a one-time extension for an additional 6 months. This is to ensure the integrity of availability of data for legal and investigate purposes. That once computer data preserved, transmitted or stored by a service provider is used as evidence in a case, the mere furnishing to such service provider of the transmittal document to the office of the prosecutor shall be deemed a notification to preserve the computer data until the termination of the case. The service provider ordered to preserve computer data shall keep confidential the order and its compliance. This statement specifies that when computer data stored by a service provider is used as evidence in a case, providing the transmittal document to the office of the prosecutor notifies the service provider to preserve the data until the case is concluded. Furthermore, the service provider is required to maintain confidentiality regarding the preservation order and its compliance. This is to ensure the integrity and security of the evidence for legal proceedings. Section 14. Disclosure of computer data. Law enforcement authorities, upon securing a court warrant, shall issue an order requiring any person or service provider to disclose or submit subscribers' information, traffic data, or relevant data in its possession or control within 72 hours from receipt of the order in relation to a valid complaint, officially documented and assigned for investigation, and the disclosure is necessary and relevant for the purpose of investigation. This statement outlines that law enforcement authorities with a court warrant can issue an order for any person or service provider to disclose subscriber information, traffic data, or relevant data within 72 hours from receipt of the order. This is only applicable in cases officially documented and assigned for investigation, and when this disclosure is necessary and relevant to the investigation's purpose. The purpose of this is to ensure expedited access to information vital for ongoing investigations while maintaining legal authorization through a court warrant. Section 15. Search, seizure, and examination of computer data. Where a search and seizure warrant is properly issued, the law enforcement authorities shall likewise have the following powers and duties within the time period specified in the warrant to conduct interception as defined in this act. A. To secure a computer system or a computer data storage medium. B. To make and retain a copy of those computer data secured. C. To maintain the integrity of the relevant stored computer data. This statement indicates that when a search and seizure warrant is lawfully issued, law enforcement authorities have the power and obligation to conduct interception as defined in the relevant legal act within the time frames specified in the warrant. This implies that they are authorized to carry out the authorized interception activities as per the terms of the warrant, thus ensuring adherence to legal procedures in obtaining evidence for investigative purposes. Letter D. To conduct forensic analysis or examination of the computer data storage medium. And letter E. To render inaccessible or remove those computer data in the access computer or computer and communications network. In this statement outlines the specific powers and duties or law enforcement authorities to conduct forensic analysis or examination of computer data storage mediums, as well as to render inaccessible or remove access computer data or data on computer and communications network. These actions are intended to enable the authorities to thoroughly examine and analyze digital evidence while also ensuring that potentially harmful or illicit data can be contained or removed as necessary for legal and investigative purposes. Section 16. Custody of computer data. All computer data, including content and traffic data, examined under a proper warrant shall within 48 hours after the expiration of the period fixed therein be deposited with the court in a sealed package and shall be accompanied by an affidavit of the law enforcement authority executing it stating the dates and times covered by the examination, and the law enforcement authority who may access the deposit among other relevant data. The law enforcement authority shall also certify that no duplicates or copies of the whole or any part thereof been made or it made, that all such duplicates or copies are included in the package deposited with the court. In this statement, authority must follow specific legal procedures in order to access and examine computer data, including obtaining a proper warrant and depositing the data with the court. Within 48 hours after the expiration of warrant period, an affidavit must also be provided detailing the dates and times covered by the examination, as well as information about who may access the deposit. This ensures that the handling of computer data is conducted in a lawful and transparent manner. The package so deposited shall not be opened, or the recordings replayed or used in evidence, or then contents revealed, except upon order of the court, which shall not be granted except upon motion, with due notice and opportunity to be heard, to the person or persons whose conversation or communications have been recorded. In this statement, once the computer data has been deposited with the court, it cannot be accessed, used as evidence, or its contents revealed without a court order. This order will only be granted after a formal motion, with proper notice and an opportunity for the affected individuals to be heard, specifically those whose conversations or communications have been recorded. This safeguards the privacy and legal rights of those whose data is being examined.
Section 17. Destruction of computer data. Upon expiration of the period as provided in Section 13 and 15, service providers and law enforcement authorities, as the case may be, shall immediately and completely destroy the computer data subject of preservation and examination. So in this section, section 17 of the destruction of computer data, so it refers to the international destruction or alteration or deletion of computer data without proper authorization. So this can include activities such as hacking, malware, attacks, or unauthorized access to computer system to delete or manipulate data. So the purpose of this section is to deter the penalized individuals or entities who engage in these harmful acts. It is important to note that the specific of this section may be vary depending on the jurisdiction and applicable laws. Dumako naman tayo sa section 18, the exclusionary rule. So, any evidence, procedure without a valid warrant or beyond the authority of the same shall be inadmissible for any proceeding before any court or tribunal. So, in this section, exclusionary rule. So, it is a legal principle, prohibits evidence obtained unlawfully or in a violation of the defendant's constitutional rights from being admitted in court. So, it is served as a deterrent to unlawful. So, police conduct and help protect individuals from violation of their Fourth Amendment rights against unreasonable searches. So, if evidence is deemed inadmissible under the exclusionary rule, so it cannot be used against the defendant in a criminal trial. Section 19. Restricting or blocking access to computer data. When a computer data is prima facie found to be in violation of a provision of this act, the DOJ shall issue an order to restrict or block access to such computer data. So in this section, section 19, restricting or blocking access to the computer data. So it refers to the measure taken to limit or prevent unauthorized entry, modification, or retrieval of electronic information. In legal context, this may be involved sa statutory provision aimed at regulating access to computer system and data. Such measures are often implemented to safeguard sensitive information, prevent prevent cybercrime and ensure data privacy. Laws addressing this issue typically outline the condition under which access can be restricted, the rights of the owners, and the penalty for unauthorized access for tampering with computer data. So, the Section 20 non-compliance, so failure to comply with the provision of Chapter 4, hereof specifically the orders from law enforcement authorities shall be punished as a violation of Presidential Decree number 1829 with imprisonment of prison, correctional in its maximum period of a fine of 100,000 pesos or both for each every non-compliance with an order issued by law enforcement authorities. For Section 20, it addresses non-compliance with the provision of Chapter 4. Particularly, orders from law enforcement authorities failure to comply is treated as a violation of Presidential Decree number 1829. So, the penalty includes imprisonment of prison, correctional in its maximum period of a fine or 100,000 pesos or both for each instance for non-compliance with an order issued by law enforcement authority. So this underscores the seriousness of adhering to the specific regulation and the potential legal consequences for non-compliance.
Chapter 5 Jurisdiction. Section 21 Jurisdiction. The regional trial court shall have jurisdiction over any violation of the provision of this act, including any violation committed by a Filipino national regardless of the place of commission. Jurisdiction shall lie if any of the elements was committed within the Philippines or committed with the use of any computer system wholly or partly situated in the country, or when by such commission any damage is caused to a natural or judicial person who, at the time the offense was committed, was in the Philippines. There shall be designated special cybercrime courtsman by specially trained judges to handle cybercrime cases. Jurisdiction is defined as the authority to hear and determine its cause or the right to act in a case. In addition to being conferred by the Constitution and the law, the rules settle that a court's jurisdictions over the subject matter is determined by the relevant allegation in the complaint. The law in effect when the action is filed and the character of the relief irrespective of whether the plaintiff is entitled to all or some of the claims asserted. On the other hand, sa kabilang banda, jurisdiction is the power to hear and determine cases of the general class to which the proceeding in questions belong. Jurisdiction is a matter of substantive law. Chapter 6 International Cooperation. Section 22 General Principles relating to international cooperation. All relevant international instruments on international cooperation in criminal matters, arrangements agreed on the basis of uniform or reciprocal legislation, domestic laws to the widest extent possible for the purpose of investigations or proceeding concerning criminal offenses related to computer system and data, or for the collection of evidence in electronic form of criminal offenses shall be given full force and effect. The DOJ shall cooperate and render assistance to other contracting parties, as well as request assistance from foreign state for purpose of detections, investigation, and prosecution of offenses referred to in the Act and the collections of evidence in electronic form in relations. Like, provide assistance to a requesting state in the real-time collection of traffic data associated with specified communications in the country transmitted by means of computer system with respect to criminal offenses defined in the Act of which real-time collection of traffic data would be available. Chapter 7 Competent Authorities. Section 23 Department of Justice or DOJ. There is hereby created an Office of Cybercrime within the DOJ designated as the central authority in all matters related to international mutual assistance and extradition. Here are the function of duties of DOJ. act as a competent authority for all requests is for assistance for investigation or proceeding concerning cybercrimes, facilitate the provisions of legal or ethical advice, preservation and production of data, collection of evidence, giving legal information and local of suspect. Section 24, Cybercrime Investigation and Coordinating Center. There is hereby created within 30 days from the effectivity of this act an interagency body to be known as the Cybercrime Investigation and Coordinating Center or CICC under the administrative supervision of the Office of the President for policy coordination among concerned agencies and for the formulation and enforcement of the National Cybersecurity Plan. Sinasabi dito na ang miyembro ng CICC shall be constituted as an executed committee and shall be supported by the secretariats specifically for cybercrime, administration, and cybersecurity. The secretariat shall be manned from existing personnel or representatives of the participating agency of the CICC.
Section 25, Composition. The CICC shall be headed by the Executive Director of the Information and Communications Technology Office under the Department of Science and Technology ICT o DOST as Chairperson with the Director of the NBI as Vice Chairperson, the Chief of the PNP, Head of the DOJ Office of Cybercrime, and one representative from the private sector of academy. As members, the CICC shall be manned by a secretariat of selected existing personnel and representatives from the different participating agencies. This is a statement about the composition and structure of the Cybercrime Investigation and Coordinating Center CICC in the Philippines. The CICC is an agency that deals with cybercrime prevention and response, especially those that target children. Section 26, Powers and Function. The CICC shall have the following powers and functions. A. To formulate a national cybersecurity plan and extend immediate assistance for the suppression of real-time commission of cybercrime offenses through a Computer Emergency Response Team (CERT). The NCERT aims to formulate a national cybersecurity plan that will provide a comprehensive and coordinated approach to protect the country's information and communication infrastructure from cyber threats. B. To coordinate the preparation of appropriate and effective measures to prevent and suppress cybercrime activities as provided for in this Act. The plan will also outline the roles and responsibilities of various stakeholders such as government agencies, private sector, academy, civil society, and international partners. Letter C. To monitor cybercrime cases by participating law enforcement and prosecutions agencies. This means that the CICC collects, analyzes, and disseminates information on cybercrime incidents that are reported or investigated by various government agencies such as National Bureau of Investigations (NBI), the National Police (PNP), the Department of Justice (DOJ), and the Department of Information Communications Technology. D. To facilitate international cooperation on intelligence, investigations, training, and capacity building related to cybercrime prevention, suppression, and prosecution. This means that the CICC works with other countries or international organizations to share information, resources, expertise, and assistance on cybercrime issues. E. To coordinate the support and participations of the business sector, local government units, and non-government organizations in cybercrime prevention programs and other related projects. The CICC is responsible for coordinating the support and participation of the business sector, local government units, and non-government organizations in cybercrime prevention program and other related projects. This means that the CICC works with various stakeholders such as private companies, local authorities, and civil society groups to involve them in the development and implementations of policies, strategies, programs, projects, and initiatives that aim to protect the country's information and communications infrastructure for cyber threats. F. To recommend the enactment of appropriate laws, issuance, measures, and policies. This means that the CICC advises the Congress, the President, and other relevant authorities of how to improve the legal framework and regulatory environment for addressing cybercrime issues. G. To call upon any government agency to render assistance in the accomplishment of the CICC's mandated tasks and function. This means that the CICC can request or require the cooperation or support of any government agency that has relevant information, resources, or expertise in relation to cybercrime prevention and response. H. To perform all matters related to cybercrime prevention and suppression, including capacity building such as other functions and duties as may necessary for proper implementations of this act. Developing and implementing standards, guidelines, protocols, or procedures for cybercrime prevention and response, such as cyber hygiene, cyber resilience, cyber incidents management, and others. Chapter 8. Final Provisions. Section 27. Appropriations. The amount of 50 million pesos shall be appropriated annually for the implementations of this act. This is a statement about the budget allocation for the Cybercrime Prevention Act of 2012, officially recorded as the Public Act Number 1017-5. This is a law in the Philippines that was approved on September 12, 2012. It aims to address legal issues concerning online interactions and the Internet in the Philippines. Section 28. Implementing Rules and Regulations. The ICT o DOST, the DOJ, and the Department of the Interior and Local Government, DILG, shall jointly formulate the necessary rules and regulations within 90 days from approval of this act for its effective implementation. This means that these three government agencies are responsible for drafting and finalizing the IRR, and they have do it within 3 months after the President signs the law.
Section 29 Separability Clause. If any provision of this Act is held invalid, the other provisions that affect shall remain in full force and effect. So in this section, the Separability Clause, as started in Section 29 of this Act, ensure that any provision within the Act is deemed invalid or unconstitutional. It will affect the validity of the other provision. In other words, if one part of the Act is found to be invalid, the rest of the Act will still remain in effect. And this clause is included to prevent the entire Act from being invalidated due to the invalidity of a single provision. Section 30 Repealing Clause. All laws, decrees, or rules consisting with this Act are hereby repealed or modified accordingly. Section 33 of Republic Act No. 8792 or the Electronic Commerce Act is hereby modified accordingly. So Section 30 Repealing Clause. The repealing clause, as started in Section 30 of this Act, declares that any existing laws, decrees, or rules that are inconsistent with this Act will be repealed or modified accordingly. This means that any previous legislation or regulation that conflict with the provision of this Act will no longer be in effect or will be adjusted to align with the new Act. In addition, Section 33 of Republic Act No. 8792, also known as the Electronic Commerce Act, will be modified in accordance with the provision of this Act. This implies that a specific provision within the Electronic Commerce Act will be omitted or altered to comply with the new Act being discussed. Thus, Section 31 effectively, this Act shall take effect 15 days after the completion of this publication in the Official Gazette or in the List 2 newspaper of general circulation approved. To Section 31 effectively, it means that once that Act has been officially published in the designated channels, it will become enforceable and applicable after the specified 15 days period. The purpose of this clause is to provide a clear timeline for when the Act will take effect, allowing for sufficient notice and preparation for all concerned parties.